You're listening to Soundside. I'm Libby Denkman. Opponents of Washington's new income tax on high earners are looking to fight the law on a couple of fronts, on the ballot and in court. Earlier this month, we talked with political donor and activist Brian Haywood about his efforts to file a referendum to ask voters to block the tax this fall. And last, Citizens Action Defense Fund, a conservative nonprofit, filed a legal challenge to the tax in Klickitat County Superior Court, claiming the tax violates the state's constitution. At the center of this argument is a nearly 100-year-old state Supreme Court ruling. Rob McKenna is a former Washington State Attorney General and candidate for governor. He's one of the attorneys representing the plaintiffs in that suit against the so-called millionaires tax, and he joins me now. Rob, thank you very much for being back on Soundside today, and hello.
Oh, thanks. Thanks for having me back. I appreciate it.
So just a reminder, if folks have been tuned out, what we're talking about here is something the legislature recently passed. It's a 9.9% tax on every dollar of income over $1 million. It would kick in for 2028 incomes. The revenue is expected to be between $3 and $4 billion for the state starting in 2029. And this legal challenge was widely anticipated. I'm going to just read from the very start of your lawsuit, where you and your team write, quote, "This case is about what happens when the political branches openly defy the limits of their founding document as interpreted for nearly a century by their independent and coordinate branch of government." So what do you mean by that? Can you briefly lay out your team's legal reasoning in the case?
So in 1930, Washington voters overwhelmingly approved a new definition of property in the state constitution. The goal was to expand the reach of property taxes beyond real property to every kind of intangible property, stocks, bonds, money, income. So the new definition of property adopted by the voters is that property is everything, tangible and intangible, subject to ownership. And in 1933, there was the first of a series of Supreme Court decisions that have continued until just a couple of years ago. And we had another decision which said, look, income is property under that definition because it's part of everything, it's an intangible, and we have ownership rights to our income. In 1934, voters were given the first of 6 opportunities to amend the Constitution when the legislature sent a constitutional amendment to the ballot, and the 1934 amendment would have excluded income from the definition of property. That would have enabled a graduated income tax instead of the current system, which allows an income tax so long as the tax on income meets the rules for property taxes. It has to be uniform, no higher than 1%. And voters rejected that constitutional amendment. They did not want to exclude income from the definition of property. 5 more attempts were made to amend the Constitution. And then, that's a big lift. The state legislature has to find 2/3 majorities in the House and the Senate, send the measure to the voters for majority approval. And the voters rejected it every single time. The last time, which was back in the 1970s, the proposal to allow graduated income tax to change the definition of property was rejected 77% to 23%. There have also been 4 ballot measures, initiatives that would have created a graduated income tax. The most recent in 2010, Initiative 1098, those also were all rejected. So 10 times in a row, starting in 1934, the voters have rejected a change to our Constitution's definition of property, have rejected graduated income taxes. So you have the public votes, you have a string of Supreme Court decisions, many of them, not just the original 1933 decision, which is the only one that tax proponents want to talk about. For some reason, they want to ignore the other ones. And then you have the plain language of the Constitution, that property is everything, tangible and intangible, subject to ownership. And all that taken together is what we're referring to in our complaint when we say the legislature ignored well-established law and passed a graduated income tax in defiance of the Constitution and the voters' will and the Supreme Court's repeated decisions. And now that case is in court.
So we are talking about the 1933 decision, at least, that kind of started all of this, the Colleton versus Chase decision. And that was a 5-4 ruling. And as you say, it designated income as property, and therefore property has to be taxed uniformly. And that has been the basis from which all these other rulings that, have swatted down. Yeah, go ahead.
Well, yes and no. I mean, yes, they all mentioned Colleton, of course. It was the
Mm-hmm.
first decision after the constitutional amendment was adopted, but they all looked at the language in the Constitution and reached the same conclusion.
So you're basically saying it's not all resting on Colleton in your reading. Yeah.
This is not one of those cases where the Supreme Court had to invent something, like find something inferred in the Constitution, create a new right. This is all based on the plain language of the Constitution. And remember, the voters have reaffirmed that language 10 times, or reaffirmed the language in the Constitution 6 times, and also rejected 4 income tax initiatives. So there's nothing new about this at all. Every decade or so we go through this.
Let me ask you about that. So in the plain language of the Constitution, it says that property is defined as, quote, anything, whether tangible or intangible, subject to ownership. Now, I've seen, of course, Democrats are sharpening their knives for this fight because they believe this is the time that they will be able to overturn this definition of income as property and allow an income tax, a graduated income tax, for the first time ever. And the critics have said, these rulings on income as property are outdated, and that most states in the country see income as like an inflow, not an asset, currently subject to ownership, or that, they count state income as, they allow state income taxes because they're excise taxes or some other types of taxes. And I understand you don't find that persuasive, but why don't you find that persuasive?
Well, first of all, the language in the Constitution has not changed, and the voters have declined to change it 6 times, right? So unless you think income is not part of everything and is not an intangible and isn't subject to ownership, it's clearly covered by this definition. And the voters have clearly said that's the way they want it. And they've rejected, effort after effort after effort to change it. They don't want to change it. And it's notable that the people you're talking about are doing everything they can to keep this issue away from the voters. If they're that secure in it, why don't they send another constitutional amendment to the ballot? Let the voters have their say. Why are they blocking this bill from a referendum vote? Secondly, with regard to other states, the other states don't have our definition of property. Our state has one of the 2 broadest definitions of property in America. The other one is in Pennsylvania. And other states that have definitions of property, not quite as broad as ours, but broad enough that they couldn't have an income tax, amended their constitutions to allow an income tax. And that's exactly what the legislature has tried time and time again over the years. Unfortunately, for those income tax backers, all of those efforts failed. The voters have declined to change the Constitution. They like the way it is, and those votes are by very large margins. It's analogous to the voters in Oregon being asked many, many times to approve sales taxes in Oregon and always rejecting them. So, I find it's kind of disingenuous, that the people who are making the claims you are, this is just one 100-year-old case. False. Oh, this language is not properly interpreted to exclude income. False. Oh, other states have income taxes and they have broad definitions of property. False. All of that is false. The other states amended their constitutions and they didn't have such broad definitions of property to begin with. So this is not a case of whether we can have an income tax. We can, but to have it, we have to respect the will of the voters, and we have to amend the Constitution, and that requires the voters to approve it. And the backers of this tax clearly don't want the voters to have that opportunity.
And I'll note that Pennsylvania has a flat income tax today for reasons that you have noted here, that income is considered property, and the state Supreme Court there did strike down a graduated income tax in the 30s. Even at the time, I think Colleton being a closely decided case, and you've noted that you don't want to rest all this on Colleton. I think that the perception is that Colleton will have to be overturned in order for Democrats to get their way here and to be able to have the income tax remain in effect. I'm just curious if this ruling, to kind of take your lawyer hat and then also your policy hat at one go here, if this ruling does go against you, what do you think the impact is on the state, beyond the current millionaires tax going into effect?
Well, I want to address that, but let me just point out this is not just a matter of Culleton.
Hmm.
All right, that was the first decision, and there have been many decisions since then, in 1937 and 1951 and later, that have all reached the same conclusion. Right? This is not just about one case, not just about one Supreme Court panel. It's about a series of panels, and they're all looking at the language of the Constitution and saying, well, income is an intangible, it's subject to ownership, so it's covered. So we can have an income tax if we amend our Constitution. Secondly, the policy impact here, if this income tax is allowed to stand, is multifold. One is, they like to call it the millionaires tax. Like in the title, they don't even use the word income tax because they're trying to like pretend it's not an income tax. But remember, once this is approved, if the Supreme Court overturns a series of Supreme Court decisions, reimagines the meaning of the plain language of the Constitution, ignores the voters' will, if they do all of that, then this tax will be spread to other folks in this state. There's no income tax in our country's history that has been limited to people at the top earning levels. Also, it's worth noting that the so-called millionaires tax is going to hit farmers and small business owners and others who own pass-through entities, S corps, for example, whose revenues flow through to their tax returns. This is not just about wealthy people. In fact, our plaintiffs are not wealthy. They are people who own small businesses, and they're going to be hit by this. So you're going to have a negative impact on small business. But the final point I want to make about, if you want me to talk about the policy arguments, is this. We have had a competitive advantage as a state for a long time. We've had a competitive advantage because we haven't had an income tax. And that's allowed us to have a high state tax and get away with it. But now we have a high estate tax, and we have a capital gains tax, and we have a proposed income tax. And all of those taxes together are already causing significant numbers of people to leave the state. And what that'll mean in the long term is that folks will not come here in the same numbers to start their businesses. They will not stay here to grow their businesses. And a famous example of this is, Amazon's founder, Bezos. He came here for a couple of reasons, but one of those reasons was no income tax. And as recently as earlier this year, 2026, the State Department of Commerce for Washington continued to tout the fact we didn't have an income tax as a reason that you should start your business here, grow your business here, move your business here. So there's no question it'll have an impact. I've heard that some people in the governor's office say, oh, yeah, but, look, New York has an income tax and California has an income tax. And, well, look, we're not New York and we're not California. The state you want to look at to compare is Oregon. We have a much higher per capita GDP in Washington than Oregon does, precisely because we've had so many great entrepreneurs start and grow their companies here and create huge numbers of jobs and wealth. And as a result, we have much higher per capita income than Oregon does. And that's the risk that we're running here if we destroy our competitive advantage.
I think that when Democrats look at this, the survival of the capital gains tax from the ballot challenge a couple years ago was kind of the signal that said, okay, voters in Washington and the sentiment of the public has changed, and they want to see wealthier people pay what they see as their fair share in the state. This conversation about the regressive nature of Washington's tax code, I mean, we have a higher burden of sales tax and business taxes than many other states that rests more heavily on lower income people and smaller business owners. I mean, for you, what is the solution to balancing Washington's tax code in a fair way? Do you buy this, that, the Democrats are arguing that this is necessary to make things fair in the state?
Well, first of all, their narrative that we have the most progressive tax system in the country is just phony.
Well,
they have one study. They have one study out of Berkeley that says that they got to that conclusion by excluding the B&O tax and by assuming that renters pay property taxes, which of course they don't.
Do you disagree, though, that there is like a rather high sales tax and business tax burden on the state? Yeah, relatively.
Yes, and how much is that tax being reduced with the imposition of this tax? I mean, almost not at all. Almost not at all. They have like a few minor changes to the sales tax involving like hygiene products at the store. If they were serious about this, they would actually try to make a significant reduction in the state sales tax. reduce property taxes, but they're not. The people who pay more of their share of their income in taxes in this state are not going to see any meaningful reduction in those taxes as a result of. And once this tax is upheld, if the backers have their way, they're going to be exposed to an income tax as well. And we really will be like California, except unlike California, we'll have a high estate tax, so that people who have grown small businesses and want to pass it along will be penalized for doing that. Regarding the capital gains tax, that was passed as an excise tax. And I argued in the court, I don't think it's an excise tax. It's based entirely on income. But the Supreme Court said, no, we think it actually is an excise. Okay. But they made a point of distinguishing it from an income tax. They said, oh, if it's an income tax, that's a different story because because what the language of the Constitution says. And I've heard that one legislator claimed, oh, this is actually an excise on income. It's not. It's an income tax. The word excise does not appear in this bill, so that is a false statement as well.
Rob McKenna is a former state attorney general of Washington, and he's leading the legal challenge to the income tax on high earners passed by Democrats in the state legislature this year. Rob, always appreciate you coming on and making the case. Thank you.
Great questions. Thanks, Libby. Thank you.
Thanks for listening to Soundside. Don't forget you can listen live on KUOW 94.9 FM Seattle at noon and 8 p.m. Monday through Thursday, or anytime online at KUOW.org or on your favorite podcast app.